All right. Prof Omenya, is this 2017 all over again? Caroline says this is 2022.
Yeah, I think it's quite interesting, and of course we're getting into that space where we'll be told over and over again that the law is very clear on these issues, and each side would be, disagreeing. I think this is a very interesting issue that we don't have in our professions, but it's a fundamental, basis of trade in the legal profession, where you say the law is clear, then after that you demonstrate how unclear it is. Yes, I mean it's actually pretty interesting, and I'm very happy that Professor Shianya is here, because I felt that the sort of detail and information we have as laymen in relation to this particular case, we're getting into a situation where we're going to be out of our depth, when we start actually analyzing the legalese. Yeah, but of course I'm happy that Ben is here, and I hope he'll be wearing his hat as a constitutional lawyer and an academic rather than a representative of a particular client, so that we have a bit more clarity on this particular matter. Yeah, but I think for me, from where I sit, is that in each of these cases we've seen actually progress. We've seen progress in terms of the interpretation of the Constitution, in terms of the implementation of the law, and so on, and progressively, of course, from jurisprudence perspective, I think we saw Raila 1, we saw Raila 2, we've seen the famous Minor Kiai ruling, and yes, now from the conversations that Right Honorable Raila, put on the table, not the conversation, but actually the statement, and from the statement of the IBC, it seems like the argument is going to be about how the institution of the chairman of IBC functions, and how the IBC as a total institution with the commissioners and the chair actually function. It seems like that is one matter that was actually raised by both parties, yes. And that seems to be a different, from where I sit, it seems to be a different emphasis or a different sort of prayer that if you're referring to the legal process from that of 2017. I think the issue of 2017 was what constituted the final result, and from again what our legal friends are saying was that yes, the Kiai ruling also had an issue about how the institution of the IBC was to operate, and that of the chair, and the differing opinions that that was basically garnished. It was conclusion of that particular matter. It was not the main issue that was being canvassed, to being sought for in terms of interpretation in the Supreme Court. But then, of course, there's other opinion that this was material to the extent that the Supreme Court judges had to pronounce themselves to that. Yeah, but for me, I'm very happy, because I think through these particular processes, through our democratic processes, through the court processes and so on, even laymen like me and Mose can actually sit here and discuss the Constitution. Exactly. I was very happy when I went home yesterday. My wife, she always has a copy of the Constitution. She was reading this thing and asking me what it actually means. And I think the law, as clear or as milky as it is, should actually be demystified to the population, so that we understand, the sort of fundamental principles that guide us and the rights, so that the law does not just become, for lawyers, as it actually were, because these laws are actually meant to govern the general populace. That's partly why I can sit here confidently and discuss our Constitution, and discuss jurisprudence, and discuss acts of parliament, and so on, because those have been put to govern me and my conduct. And of course, competitors, whom I must say, Raila Odinga is an engineer, and the new president-elect, Ruto, is actually somebody from the sciences. So that's my point, that I'm urging Kenyans, let's feel confident doing the mathematics, because mathematics is available for all Kenyans. Let's feel confident discussing the law, because the law is available for all Kenyans. I stop there. I stop there.